Today, we're cracking open a landmark Canadian Supreme Court case that completely changed the game for the rights of the accused. It's called R.V. Garofoli, and it forced our justice system to answer a really tough question. What happens when the most important evidence against you is a secret?
Seriously, just think about that for a second. You're on trial. The prosecution's entire case is built on evidence you're not even allowed to look at. The reasons, the justifications, the whole basis for why they're investigating you is sealed away in a file. How in the world are you supposed to defend yourself? Well, that's not a hypothetical. It was the exact dilemma at the very heart of the Garofoli case.
All right, let's set the scene. Our story kicks off back in the early 1980s. It's got all the makings of a legal thriller, a drug conspiracy charge, police wiretaps, and a critical piece of evidence locked away from prying eyes.
So, the man at the center of all this is John Claude Garofoli. He gets charged with conspiracy to import narcotics. Now, what's really important here is that the Crown's case wasn't built on things like fingerprints or eyewitnesses. Nope. It rested almost completely on private phone calls that the police had secretly recorded.
Now, for the police to get those recordings, they couldn't just start listening in. They needed something called a wiretap authorization. You can think of it like a search warrant, but for conversations. And to get one, police have to give a sworn statement to a judge. It's called an affidavit, explaining exactly why they think a crime is happening and why a wiretap is going to help prove it. And here is the big catch. Once the judge signed off on that wiretap, all that information, the entire justification from the police, was put into a file, sealed shut, and locked away. This is the sealed packet. It held all the secret reasons the police were listening to Garofoli's private calls. And, under the rules at the time, his defense team couldn't see a single word inside it. You can see how this creates a massive problem, right? Garofoli's lawyers wanted to argue that the police wiretap was improper, maybe even illegal. But to even begin to make that argument, they needed to see the affidavit. It was a total catch-22. You can't challenge the evidence without seeing the file, but the law says you can't see the file. This fundamental, impossible conflict is what sent this case rocketing all the way to the Supreme Court.
So, what the court had to do was this really delicate balancing act between two powerful and totally competing interests: the rights of every single person versus the needs of the police to do their job. This slide just lays out that core tension perfectly. Look, on the left, for the accused, you have the right to a fair trial. You've got the right to make full answer and defense, which is just a legal way of saying you have to know the case against you to fight it. And, of course, you're protected from unreasonable search under the Charter. But then, on the right side, you've got the state's interests. They need to protect confidential informants, they have to run effective investigations, and they definitely want to keep their police techniques secret. The court had to find a way to make both of these legitimate sides work together. Now, Garofoli's fight to get inside that sealed packet was anything but easy. This was a long, hard-fought legal battle that had to climb through every single level of the Canadian court system. You can see how it worked its way up. At the first trial, the judge said, nope, not opening it, and Garofoli was convicted. So he appealed. The Court of Appeal actually took a step forward. They ruled that the packet should be opened, and they gave the defense an edited copy. But they still upheld his conviction. So that set the stage for the final showdown at the Supreme Court of Canada, which basically had to settle this whole mess once and for all. And this quote from Justice Sopanka, who wrote the decision, it gets right to the heart of the court's logic. He basically pointed out how absurd the old system was. What's the point of having rights written down in law if you then deny a person the tools to actually use them in a courtroom? It just creates an impossible situation for the defense. So in response, the Supreme Court didn't just make a little tweak to the system. No way. It created a whole new procedure, a set of rules that have become a cornerstone of Canadian criminal law ever since. The court came up with this brilliant 4-step framework. Let's just walk through it. Step 1, and this is the big one. The court said the accused has a fundamental right to access that sealed packet, period. Step 2, to protect the police's interests, a judge has to go through it first and black out any sensitive information, like an informant's name. That's judicial editing. Step 3, the defense gets this edited version, and now they can actually challenge the wiretap's legality at trial. And Step 4, this is huge. The defense can now ask the judge for permission to cross-examine the officer who wrote the affidavit in the first place to really put their claims to the test. What's really fascinating here is that the court looked at the American rule on this from a case called Franks v. Delaware, and they deliberately chose not to follow it. The American standard made it nearly impossible for a defendant to ever get a chance to cross-examine. But the Canadian court, guided by our Charter of Rights, decided that the right to make a full defense was just too important. They created a uniquely Canadian system that gives the accused a real shot at challenging secret evidence. So, after all that, what happened to Jean-Claude Garofoli himself? Well, the Supreme Court applied its brand new rules to his case, and because he had been denied that crucial chance to cross-examine the officer who swore the affidavit, the court found his trial had been unfair. They threw out his conviction and ordered a completely new trial.
Look, the Garofoli decision wasn't just about one man's trial. Its impact has been absolutely profound, and it continues to shape our entire justice system to this day.
The year was 1990, and you really have to see this decision as a major pivot point in Canadian law. It fundamentally rebalanced the scales of justice between the power of the state to conduct surveillance and the rights of the individual to privacy and a fair trial. I mean, the legacy of this case is immense. The whole procedure it created is now a standard part of our legal world. We literally call it a Garofoli hearing. It put real teeth into the right to make a full defense. It created this clear, strong framework for balancing privacy with policing. And maybe most importantly, it cemented the role of trial judges as the essential guardians of our charter rights, making sure that secret evidence can't lead to an unfair result. But all of this leaves us with a huge question for today. The Garofoli case was decided in a world of landlines and payphones. We live in an age of constant digital surveillance, smartphones, and massive data collection by huge corporations and the government. So, does the balance that was struck back in 1990 still work for us today? Or do we need a whole new set of rules for this new digital era of secrets?